morning, and thank you for joining us today. It's great to be hosting this webinar with my colleagues. Today, we are going to be discussing how you can protect that valuable confidential information and also valuable clients and customers, stop them getting into the wrong hands and those naughty employees behaving like they shouldn't be. I think we're probably all feeling the shift at the moment, and certainly vulnerabilities in the employment market, whether that's from our own decision making redundancies, or whether it's the after effects of COVID and lockdown. So either way, we thought business protection at the moment is just a priority in these uncertain times. So today I'm joined by a couple of our specialist lawyers at HCR and David Kearns from Expert Investigations. So without further ado, let's launch into the slide deck, please, Amelia. If we go to the first page, there's the agenda there. So first and foremost, we're going to hear from David, like I said, from Expert Investigations. Then we're going to hear from Ellis Wolby, who's principally an employment specialist here at HCR. And then back to David, and then back again to Jenny there, who's going to talk about the litigation aspects, which are very interesting angle for us all to consider. So starting with you, David, I know we've got a few thoughts here about the psychology behind employees and why they behave this way. So let's start with that, David. Over to you.
Thank you, Rachel. Morning, everybody, and thanks so much for joining us this morning. My name's Dave Kearns. I'm Managing Director of a company called Expert Investigations. We're a commercial detective investigation agency, and for 20 years we've been investigating dishonesty in the workplace, an awful lot of which is based around theft of data and theft of IP by employees. And during that time, I've also done the academic studies, and I think that this slide here is really, really significant. It was originally established by a very eminent American criminologist and psychologist called Donald Cressy, and he used this purely for asset misappropriation. But I feel that you can use this for every element of dishonesty within the workplace, and particularly with today, with regards to the aspect of employee dishonesty with theft of data and theft of IP. Now, what we've got here is law-abiding, normal citizens that suddenly take the opportunity to become dishonest, and in this occasion take the data. What I really have to impress on you is that you have to look at this in a mature and a realistic vein, because the amount of times that people have said this would never happen to us, and then it has happened, and you are chasing up afterwards. What you have to understand here is that an employee has the opportunity to take that data, to appropriate all of that information. They have that opportunity around their normal working activity. They rationalize their actions in their own mind. Now, that rationale could actually be the fact that they feel it's their data, it's their LinkedIn profile, it's the data that they have built, it's the relationships with the clients that they have nurtured, and they will rationalize in their own mind why they should have access and be able to take that data. And in the final corner is the motivation. And the motivation is always for financial remuneration. Never in 20 years have I seen anybody in the employment field being dishonest for charitable and philanthropic reasons. It's always for that financial motivation. So if you are taking that data and you are starting your own business, that is going to be financially really viable to you, and exactly the same if you are going to a competitor or another organization. And these employees do this around their normal routine activity, and they make a rational choice to do it. So always remember, they have the opportunity, they rationalize their actions, and the motivation is always financial remuneration. But one thing that is pretty significant now, looking at the rationale, is we are in unprecedented times. COVID has changed the workplace. It's almost, with the amount of redundancies and the state of the economy, it's almost survival of the fittest with many employees. And therefore, their rationale might actually change, that they feel that they need to take that data because it gives them a greater fighting chance within the employment field and within employment opportunities. Rachel?
Yeah, that's great. Thanks, David. I think understanding that piece is really helpful, and putting employees' behaviours into perspective. I think a lot of clients find that really useful 5 minutes just to spend exploring that when looking at implementing and what PTR's post-termination restrictions might be relevant for those individuals. So really interesting to hear that. Thank you, David. So for us now, the next logical step is, what protection can you put in place as an employer? And Ellis, as I said, is our employment specialist, and she's going to guide us through this aspect. So over to you, Ellis.
Thank you, Rachel, and good morning, everyone. So David has just touched on the employee psychology element there. I think a good place for me to start is perhaps the employer psychology. So business protection, why bother? So you wouldn't necessarily and intentionally leave your office unlocked overnight. You wouldn't leave your company card on a train, and I presume you wouldn't carry out business uninsured. So it poses the question, why would you take a risk with your workforce? Your workforce are arguably your most valuable asset, and yet, ironically, when things go wrong, they can also be extremely costly to you. It's really important that we have both clarity and certainty at the beginning of the commercial relationship, so that the employer and the employee both know what's expected of each other, not only during that employment relationship, but crucially afterwards when they go elsewhere. I suppose another element to consider in terms of why bothering with business protection is that even if you're not in the mindset right now of looking to perhaps sell your business in the current market, you might be later down the line. And of course, a well-protected business is obviously going to be more commercially appealing. It's going to be more valuable to that prospective buyer. So it makes sound business sense to ensure that commercially you have all of the right protection in place, which includes business protection with your workforce. So we've now spent some time looking at why bother. And if we move on to the next slide, so what actually needs protecting? So you've spent a great deal of time and money and energy not only establishing your business, but also developing it, nurturing it, growing it. And the last thing you need is some pesky rogue employee essentially, damaging all of that hard work and investment. So there are some common scenarios that you will need to protect against. And those scenarios typically will be the following. So you've got the unauthorized use of and sharing of confidential information and sensitive data. You've got ex-employees unfairly competing against you, whether that's moving on nicely to a new employer or actually setting up in direct competition with you. We've got ex-employees looking at stealing or attempting to steal, even if they're not successful, clients, key customers, contacts, even suppliers. And then lastly, we've got ex-employees who are sat there thinking, I've got quite a cushy team here, it's all working very nicely, but actually over there on the other hill, there's a better benefits package, there's a slightly higher raise in salary, there's a less lengthy commute, whatever it might be. Again, going back to David's employee psychology and motivation element there, whatever is driving that employee, they may be thinking, well, I'll just encourage my law following, my team to up and move. And of course, that leaves you high and dry. So again, another scenario that you do need to be protecting against. So we've now looked at that. So let's move on to looking at what protection is actually out there. So what can you do? What tools are at your disposal? So we know that there are options available to us. There's a whole raft of business protection provisions that you can use. I'm going to focus this morning on the top 4 that I feel of paramount importance to you. Now, the first is, as Rachel mentioned earlier this morning at the start, so confidential information, so protecting that. We want to ensure that you've got confidential information definition nicely drawn, nice strong confidentiality provisions, so it's crystal clear what is covered by or what is meant by confidential information. We secondly want to ensure that you've got post-termination restrictive covenants in place, or restrictive covenants to make it shorter. I'll come on to that in due course in more detail. It's my favourite area, really good area to get down to the nitty-gritty and the practicalities of that employment and commercial relationship. So I'll come on to that in due course. But essentially, it's of course restrictions on an employee's commercial activity after they left the employment of yourself. And of course, it's looking at restricting their commercial activity and perhaps a geographical reference, and also for a set period of time post-employment. The third key ingredient, the third kind of layer of protection that you can have, is a really well drafted, robust social media policy. Now, not only would that potentially govern how social media is used, but crucially, it would cover the ownership of lucrative business connections made via various social media platforms whilst that employee is in your employment. So they've joined you. It might be that they're perhaps in sales. It might be that they are in recruitment. They've got valuable connections on, for example, the obvious one is LinkedIn. And they're lucrative connections because they are converting to paid work. So when an employee leaves, why should they take those connections with them when they've built those connections for you, for the company during their employment? So again, a clearly drafted social media policy can prevent connections, lucrative connections, from being taken. And then last but not least, a garden leave clause. So some of you, most of you may already know what these are. Apologies if I'm teaching you to suck eggs, but it's simply a clause that makes sure that when perhaps a mid-tier to senior level employee or director leaves, we can ensure that they remain an employee for their notice period, but have them on paid leave away from the business. So we've got control over them. We can weaken and gradually diminish and distinguish any of those key relationships that that exiting employee might have with key clients, move those relationships onto, with employees who are staying with us, and that exiting employee can walk away into the sunset without still having that rapport. So those are my kind of four main business protection areas that I think are really, really paramount. So we've looked at what is actually there at our disposal. So if we move on to the next slide, we're looking at how to successfully implement, because of course, having a well-drafted contract is incredibly important. It's not worth having, a contract that's not worth the paper it's written on. We need to make sure that we can, should the need arise, successfully enforce these. So as I mentioned just before, I'm going to focus now on restrictive covenants. That's a really key area. The reason I'm going to focus on this is because although it's incredibly important, of course, to ensure that, confidentiality, social media policies, garden leave provisions, etc., that's all in place, it's really vital that you take a little bit of extra time in thinking about restrictions and tailoring those restrictions. Now, it's absolutely, again, I cannot stress how important it is to tailor them. Those restrictions cannot be a whitewash approach where you're sending out the same old, that's been around for 12 years set of restrictions for every employee. It doesn't work like that. These restrictions do need to be reasonable and they need to genuinely protect your business. They cannot go any further than that. Otherwise, you simply won't be able to rely on them. And what's the point in that? So when looking at tailoring those restrictions, you need to be pondering the practicalities. So when you've got a new joiner, or perhaps you've got someone that's being promoted, so both those scenarios would require you looking at perhaps either implementing or updating restrictions. You need to be looking at things from a holistic approach. You need to be saying to yourself, okay, well, who is this person? What's their position? How senior are they? How experienced are they? You need to be thinking about what level of confidential information and sensitive data they're going to have access to routinely as part of their employment. What information could they have access to if their mind wanted them to be looking for that? Perhaps, as David said, they were thinking of leaving and they want to make sure they've got as much confidential information to take with them as possible. You want to be considering the level of contact, frequency of contact, what type of rapport and commercial relationship are they going to be building with those key clients and customers of yours. Equally, you want to be looking at the level of influence that that employee is perhaps going to have internally. So we've looked at key contacts and clients and customers, but equally, the last thing you want is for them to build a really good team rapport and possibly take their team with them elsewhere. So again, internal influence, incredibly important factor to consider. And then finally, just sit down and ask yourself, if this employee was to go elsewhere, say they're with you for, 18 months, 2 years, 3 years, 5 years, whatever it is, they move on, what commercial risk are they going to pose to you and your business? And so to conclude, moving on to the next slide now, again, it's just reinforcing that, all of those business protection provisions are available to you. It's incredibly important to spend time truly thinking about what restrictions will apply so that you can enforce them successfully if the need arises. And a last comment from me, I suppose, is, in those SOS moments when things go wrong, and as David touched upon, people never think it's going to happen to them, and it does. In those SOS moments, you do need to act decisively and swiftly in taking action. And again, having all of those protections in place, all that right contractual documentation and policies is going to put you in the best place possible and save you time, stress, and ultimately one very big commercial headache.
That's great. Thanks, Ellis. Some really useful advice there. I think a couple of things that really kind of come out for me is that things can be done right now whilst everything is good in the employment relationship. I think that's really important. The other aspect is how important it is to tailor those restrictions to particular members of staff and particular levels of seniority and exposure they have within the business. So some really good nuggets of information. And I think my mantra for this is essentially, we want to fix the roof while the sun is shining, essentially. So really good information there. I've got to mention at the beginning that if you do have any questions, please do submit them in the Q&A box on the screens, and we'll try and get to those at the end. We've had quite a few submitted before the event, so we'll try and deal with those also at the end. So just moving away now from sort of those legal formalities, I'm going to bring David back in to just talk to us about what tools an investigator has at his fingertips. So back over to you, David.
Thanks, Rachel. First and foremost, I just need to advise you, just so you have an understanding of the investigation industry, if you are engaging with investigators, it's an unlicensed industry. There is no regulatory body. Less than 21% have professional indemnity insurance, and even less have GDPR compliance. It's an associate model where that work is passed on generally from one investigator to another. We don't work like that, but that's a different presentation. Therefore, then you can set up as an investigator tomorrow with no skills, no qualifications. You can even have a criminal record, and you don't have to have any skills or any experience. So if you are engaging with investigators, please benchmark them first, get copies of their insurance and their GDPR compliance. Next slide, please. So these are the investigative resources that are available. And Ellis has clearly pointed out there that we are looking here at prevention and disruption, so you don't have to investigate and detect it. But unfortunately, all too common, we have to alongside the solicitors and independently. So your investigation tools clearly start with Ellis and the team. Then the resources that are available. So I'm just going to take you through the kind of resources we use on a weekly basis with regards to this issue. Now, to start with surveillance, surveillance falls into two categories. That is a surveillance team that physically follow an individual and lawfully gather evidence of where they're going, what they're doing, and who they're associating with, bringing in this primary evidence that really cannot be refuted. I'm a big advocate of surveillance, conventional surveillance, because you've got a team that can adapt and unfold to what happens in front of them. Many years ago, we had a case with an individual that we'd got under surveillance on a breach of contract on post-termination. He got on a train down in London. The surveillance team jumped on the train with him. He got off in Edinburgh. He jumped into a taxi. The surveillance team jumped into a taxi behind him, uttered those immortal words, "Follow that car," and they followed him to the Hilton in Edinburgh, where he had a meeting with somebody that he shouldn't have done, and it was in breach of his contract. And that is a team that can adapt and unfold. Now, I mentioned it's all about gathering primary evidence. Now, hopefully this will resonate okay with regards to it being a webinar, but all of our teams are carrying and wearing covert cameras, body-worn cameras. So this here is a wristwatch, and in the number 6 is a covert camera. So all of the team will carry those, and they'll be able to have their arms folded and physically be recording and gathering that evidence. Now, I know you're thinking by now that this is sounding a bit like Q in James Bond, but these are just tools of the trade. They are tools to give you the evidence that you need to take back to Ellis and the team to be able to get resolution on your issue. This here is a car key fob, and in this car key fob is a covert camera. This is a phone case, and in the phone case, in the front of it is a covert camera. So even if you end up in an environment where you haven't got your phone, you've still got the case. And I actually went round a car manufacturing factory. They took the phones off us, but they never took the phone case. That's conventional surveillance, but we also use technical surveillance. Now, In my former life in the police service, we could follow people via their credit cards and via their Oyster cards and via their phones. You don't have those resources within the commercial world, but what you do have here are covert tracking devices. This is a covert tracking device. It's magnetized. You magnetize it underneath the vehicle lawfully, and you can monitor where that vehicle goes. So if you have got somebody that is on a restricted covenant not to associate with clients, say, for example, in the Southwest, we can geofence the Southwest with that tracker, and we can get alerts whenever the vehicle goes into that area. And you're not only gathering evidence, you're gathering intelligence of the movements of the individuals. Computer forensics there, this is one of the key main tools with regards to this type of investigation. And this is the lawful retrieval of data from a desktop, laptop, palm top, sat nav, printer, mobile phone. Our advice always is, if this device has been left behind in your organization, please don't get anybody to start playing with it, start looking for information, seeing what's been downloaded. You can contaminate that evidence inadvertently. Our advice is turn it off and get it lawfully retrieved. The other thing with the computer data is, that Jenny's going to talk about, is about the search and seizure order, about retrieving that data from somebody's personal device. Now, I'm just going to briefly mention here that when we have to do this, we have to look at this almost as if it is a police-style raid, because you want to use your proactive resources like surveillance to potentially monitor where the individuals are before you do your search and seizure order. Have they left the address? Do they go to work? Do they regularly go somewhere? So we're using that side of the surveillance and the tracking. But also, when we are going to that location, we want to secure it. Now, you normally only get one opportunity to get this right and get the evidence. So why do you want to turn up at a location and find that the computers have gone out the back door as you turn up with your doorstep order? So it's about looking at that environment and again securing it so that when you do execute that order, that you maintain control over where the evidence is. With our database inquiries and database research, which includes locate, trace and asset reports and background reports, that can give us an insight with lawfully gathered information of who is involved within potentially a new business, who their associates are, how they have set it up, and that allows us then to follow the investigative trail. And where's needed, statement taking as well, again in order to gather primary and circumstantial evidence. So there's a lot of investigative tools there, and within this kind of scenario, it is one of those cases whereby you use lots of different ones: the computer forensics, the surveillance, the tracking, some data research. And once you've got that primary evidence, it can come back over to Ellis and Jenny, and then they can proactively take that forward to the next stage. Rachel?
That's brilliant. Thanks for that, David, or AKA James Bond there, should I say. Really interesting, although rather scary, those covert recording devices, I think personally, because I always think of it the other way as well, of advising my employer clients about what employees might be doing in meetings and the covert recordings that might be going on in the workplace. So it does scare me on lots of different angles, all this technology, let's say. So moving on then, we've got the restrictions in place. Ellis has done her part. You've done that at the start of the employment. You've got the evidence. David's helped you with that, or another investigator's helped you with that. What next? What can we do next? And this is where I'm going to hand you over now to Jenny Raymond, who's going to discuss this part. Thank you.
Thanks, Rachel. Yeah, so next slide, please. Yeah, so as Rachel mentioned, we're now in a situation where a former employee has clearly breached their restrictions. They've been contacting your clients. That's all become apparent. You've gathered enough evidence. So what are your options at that stage? What can you do? So next slide, please. So in terms of the legal steps you can take, typically the first stage that step that we would take would be to serve a letter of claim. So that would set out full details of your claim against the former employee and provide all the supporting evidence that you'd collated at that point. As part of that, we'd also give consideration to bringing in the new employer. Often the courts are quite cynical if new employers turn around and state that they weren't aware that there were restrictive covenants in place. because generally speaking, particularly in most industries, there are restrictions in respect of what an employee can do once they depart. And so we'd be looking to draw those restrictions to the new employer's attention and make them aware that should the former employee continue, then there will be steps taken. As part of that whole process, what we'd be looking to do is to seek undertakings from both the former employee and the new employer. Undertakings are effectively promises that they will abide by their restrictions, and we'd also ask them to provide information as to the steps they've taken to date in the form of a witness statement explaining what data they've taken, the steps that they've taken to contact your clients, and ultimately ask them to provide that at this stage in this proceedings. Next slide, please. But what happens in circumstances where a former employee refuses, or often, as we can see, is that former employees decide to bury their head in the sand, hope it'll all go away, ignore all your correspondence, and yeah, like I say, hope that this all will disappear. It's at that stage that there's some analysis that needs to be undertaken. You know, do you consider that that employee will cause irreparable damage to your business? Are they likely to take key clients? What are the implications for your existing workforce? You know, it's important for you to be aware of that. Like ultimately, if key clients start to disappear, that could have cause serious irreparable damage to your business. Therefore, you do need to consider whether you need to stop them in their tracks at an early stage before it is too late. And it's at that point that the option is to consider applying to court for an injunction to stop them. Effectively, what the court would be asking the court to do is to make an order, like I say, stopping them in their tracks, and then the court would be looking to consider all of the evidence at a later stage at a final hearing. But at this interim measure, what the court would be doing is looking at the evidence before it, weighing up on balance whether the order should be granted, considering, you know, what the actual claim is against the former employee, and also considering whether damages would be an appropriate outcome in these circumstances. Often it's not. Often, you know, the risk if this employee is allowed to continue could result in significant damages, which they're just not in a position to pay. Therefore, the court will take that into consideration in deciding whether or not to grant the interim injunction. One point that Ellis has already touched upon is it is important to act promptly. The court will take into consideration if there's been a significant delay. It's harder to demonstrate to the court that this is really serious if ultimately, you know, it's been sat on for a period of time. Therefore, if you've acted promptly, you're demonstrating to the court that this is urgent, you've invited the other side to provide you with reassurance, they fail to do so, then all of that is going to help when making that application for an injunction. As part of that application, you'd also be seeking that the former employee delivers up anything that they've taken from you. So all that vital confidential information, which might include client lists, pricing strategies, etc. You'd be asking for all of that back. You don't want that to get into the hands of the new employer. The value of the injunction and the order that you obtain is that it does have a penal notice attached to it. So effectively, it mirrors what will be stated in your employment contract in terms of setting out what the restrictions are, but it does have that penal notice whereby if the former employee decides to breach that order, then ultimately they're in contempt of court. And so that would mean that they could either face a significant fine or potentially imprisonment. So generally speaking, people do abide by it. It's also worthwhile giving consideration to whether or not to join that new employer as a party to the proceedings. As I say, often the courts are somewhat cynical if a new employer turns around and says, oh, I didn't know anything about it. And ultimately, if there is evidence to support the fact that that new employer knew that those new clients had come on board, there's additional data as part of their business, then we could be looking to bring them in. Ultimately, they have deeper pockets, so often it's a useful tactic to adopt. And typically in these circumstances, notice is given to the other side. So what I mean by that is that you prepare the application, which effectively is a detailed witness statement, providing all of your evidence before the court. You'd send that to the court and you'd get a hearing date, and that would all be served on the other side. So they'd be aware of the hearing date and all the evidence against them, which would give them an opportunity to respond in advance of the hearing so the court can consider both sides of the argument. Next slide, please. However, in circumstances where you consider there's a significant risk that if they are given notice, if they are tipped off about this forthcoming hearing, then they're likely to destroy all the evidence. As David's touched upon, we can apply for what's called a search order. So that effectively enables you to turn up at the employee's premises and to search for and remove vital evidence to ensure that they don't take steps to destroy it. It is a draconian order. Therefore, in order to satisfy the court that there's a need to go down that route, you need to really be showing the court that they have got form in that regard. So it would be helpful in those circumstances, for example, if they'd already deleted loads of data when they'd handed back their work laptop, for example. And also you will have an obligation to explain to the court fully, you've got a duty of full and frank disclosure. So effectively you need to set out what your position is, as well as what they would likely be saying in response, so that the court can make an informed decision as to whether or not to make that order. Next slide, please. So in that respect, and just talking through an example whereby we were successful with obtaining a doorstep search order, we had a client whereby their managing director departed, so obviously someone of really senior position in the business. Prior to her departure, she set up a competing business, and then upon departing, she wiped all the evidence from her phone and her laptop and diverted client emails. And how that came to light was that she started emailing clients of ours, of our clients then, from her new work email, but rather than reply, they sought to forward that email and engage with someone else within the business and copied in her old work email when they responded. So it's surprising, as much as people try to be as sophisticated as possible, actually inadvertently it can all come to light. And then we obviously had a whole evidence trail of all the correspondence that had gone back and forth with our clients. So in that circumstances, we applied to court. We didn't tell the former MD, given her form and the fact that she'd wiped her phone and her laptop. We were able to demonstrate to the court that there was a real risk, that she'd do the same. So we obtained from the court what was called a doorstep search, whereby we turned up at her premises. It was a Friday afternoon, and she wasn't aware that we were going to arrive. We told her that she had to hand over her phone, her laptop, her iPad, etc. And all of that was then taken away and forensically examined by expert investigations. So that enabled us to review everything that she'd been up to, both before she'd left our client's employment as well as afterwards. In those circumstances, and is often the case in these types of cases, if you are successful in obtaining those orders at an early stage, parties are generally encouraged to settle. From a defendant's perspective, and particularly in this circumstance with the MD, she knew she was on the hook. She knew we had all the evidence, and therefore if she allowed this to continue all the way to a final hearing, she was going to be liable for significant costs. So consequently, she did come forward, a settlement was reached, and she therefore had to account for the profits that she generated from the clients that she poached. Next slide, please. So turning now to LinkedIn, and Ellis has already touched on some of this in terms of the ownership of LinkedIn, and in particular those connections that are generated during the period of your employment. It's really important to give consideration to how much you use social media, and in particular LinkedIn is often seen as a business tool. So those connections that are generated, who owns those? What happens when an employee leaves? Do they retain access to all of those key vital clients that they've connected with over the period of their employment, or are they handed back? And to that end, as Ellis has already mentioned, do you have a social media policy in place just regarding the ownership of those clients and contacts? Next slide, please. So it is a really interesting area of law, and it's one which is constantly evolving. Generally, I think everyone takes the view that LinkedIn is owned by the individual, and therefore there's nothing you can do. However, we have acted for a client in the past who had a social media policy in place. That social media policy stated that the connections belonged to our client. To that end, our client was arguing that that LinkedIn account was used as a database for its business. It used an enhanced LinkedIn account. It was a recruitment business, therefore it used LinkedIn to target not only clients, but also candidates. And we were able to demonstrate to the court that the connections generated on LinkedIn during the period of employment belonged to our client. And the order, therefore, that the court made was for that former employee to delete all of those connections generated during the period of employment as part of that order. That's quite important because obviously, like I say, LinkedIn is quite a valuable tool, and often, like particularly in that circumstance, what we found was happening was the former employee departed, was active on LinkedIn, was liking, commenting, making posts around key clients within the business, telling them where he'd moved to, and consequently all of that, we argued, amounted to solicitation and potentially dealing with those clients, which was in breach of the restrictions. Therefore, a food for thought is whether or not it's worth asking new employees to create a new LinkedIn account for work purposes when they start, or as I said, alternatively making it quite clear to them that any connections that they generate during the period of employment belongs to you as an employer. Next slide, please. So finally, from me, just a few practical steps to think about, and obviously not wanting to teach you to suck eggs, but at the same time just wanting to highlight a few key points. So in terms of confidential information, the more that you can limit access to that, the better. Does that individual employee need access to full client list, all of your pricing strategy, or can that be somewhat limited? And the same with devices that employees are able to use. Often we come and clients face difficulties if, for example, personal mobiles have been used, particularly in the current climate where people are working from home more. Effectively, that means that they've got key client data on their personal mobile, which will move with them if they were to move to a new employer. Prior to their departure, ask them to return all company property and hold an exit interview, just reiterating their restrictive covenants. So then there's no ambiguity, there's no misunderstanding as to the fact that they continue to be bound by them post their departure. If you do suspect any breaches, mind servers and emails. As mentioned in one of the case studies, it's surprising how easy it is to uncover that evidence on occasions. People think they're being really sophisticated, but actually inadvertently it all comes to light. We've also seen examples where people have just forwarded things to their personal email accounts. It doesn't necessarily have to be extremely sophisticated. But in the event that you suspect and you haven't got that key evidence, it's also worth considering appointing a forensic expert at an early stage, so to ensure that you gather that data as quickly as possible. And also, and again, not wanting to reiterate and teaching you to suck eggs, but reaching out to clients and contacts, working hard to keep them, all of that will help to reduce any damages and any losses that you suffer as a result of the actions of a former employee. So that's it from me. I'm now going to pass back to David just to chat through some of his experiences on some of the case studies I've mentioned and on some others from a forensic perspective and an investigative perspective.
Thanks, Jenny. I'll just start with the two more recent ones that we've done with Harris & Clark Rickaby's, and I should just say that everything that I've spoken about is lawful. You can conduct these investigations absolutely lawfully. There is clearly an adherence where appropriate, and normally it's only with regards to public authorities where there's restrictions with regards to the Human Rights Act and Regulatory Investigatory Powers at Work Act. You've obviously got to adhere to employment legislation, hence the team here from Harris & Clark. But everything that I've said is lawful and can be introduced. And these case studies will give you an idea how this is pieced together with coming over from the solicitors to gathering that evidence for it then to come back for its resolution. And the one that Jenny mentioned there, first and foremost with the MD, she's explained that one really, really well. The only one thing I would say with regards to that is the speed with which you have to do it. Once things start to move with these things and they get traction, you need to be able to move and be in a position to gather that evidence quickly. So from when we came over with that case with Jenny, literally sitting, waiting for the go-ahead for the order from the court to be able to go and execute that search order immediately. And the second one that is, it's so hot, it's still on the table with the Harris & Clark Rickaby team in Worcester, with an employee. The evidence, the individual was placed under surveillance, the evidence was gathered, it went back over to the solicitors, it went into the court, and there is actually a penal notice on this chap at the moment because he is breached, and he is in breach of contempt of court. And we're actually in conversation now as to whether we place him under surveillance in order that he can be arrested for that contempt of court. So these are real cases that happen. Operation Litchfield. An interesting aspect to this highlights what happens that you see in all elements of employee dishonesty. The more people that are involved And the more significant the individual on the hierarchical scale, i.e. the more senior role they have, the longer it often takes to identify the element of dishonesty or the breach of the contract, but also the costs are significantly higher as well. Now, in Operation Litchfield here, it was the sales director and the contracts manager both put their notice in at exactly the same time. And they had exceptionally good jobs, exceptionally good terms, and it's a privately owned and managed business. And they found this very suspicious and unusual. So they were given an even better package, but they refused to stay and they were leaving. So this was the warning indicator, the red flag indicator. So the individuals were placed under surveillance at the same time as data research was started on them. And we found that a business had been established, but not in their name, but with people that were connected to them through family links. The surveillance showed the location where they were working from, and the computer forensics examination showed that the 6 months previously, the two of them had been diverting contracts out of the business to their business that they were establishing because they had got the relationships with those key people in the client chain. And this was in the construction industry. So there was significant funds here that the clients were likely to lose. And in that case, exactly the same, those resources are used, the evidence is gathered, and it goes back to the solicitors for the resolution. Now, in Operation Ormskirk, this was a company that were based in Southern Ireland. They had a foothold here in the UK, and they were based around the renewable industry energy sector. Information had come to light from an existing client saying, did you know that one of your employees has started up on their own? And again, this started off with a straightforward surveillance operation to monitor the movements of this employee. First few days, nothing happened, but then he went to a new industrial unit that he was quite clearly preparing for work. He'd got 4x2 delivered, plasterboard delivered, and there was clearly some work going on in there. But after a couple of days, he was going off onto site, and he was off on site in breach of the contract because he was at our client's former clients. Not only was he breaching the contract, but actually some of our clients' employees that had gone off long-term sick were working for that employee that had breached his contract. So it's starting to get significantly bigger. At one point during that surveillance exercise, when the individual, the employee concerned, was in his factory unit, small nursery factory unit, one of our surveillance officers with a car key fob, as a delivery driver with fluorescent jacket and parcel, walks into the premises asking for the location on the address, and he was pointed to where it was. But whilst he was in there, he was able to film that there was a laptop, an iPad, and a mobile phone. That information came straight out, was sent down to the lawyers in London. They went and got a search and seizure order, and 2 days later, we were in there doing the search and seizure. And that shows how using the proactive resources can gather that evidence that puts you in the strongest position possible. As I said earlier, you generally only get one chance for this and to gather that evidence. We've got a lot of experience here working with the team at Harris & Clark, and the great thing about it is it fuses together. So therefore then the results are always in the client's favour. Hopefully that's been a little bit of use for you to see how it all absolutely links together. So Rach, back over to you.
Brilliant. Thanks for that, David. It's really useful to see how it fuses together, and I think it's definitely a team approach with these issues, definitely. Jenny, thank you for your interesting cases there. I think the key message there is one size does not certainly fit all. I really like the doorstep search option, although Jenny does tell me it's a little bit rarer than I would like to have heard, so we'll park that one on most cases, I think. Another thing is that it's often the smallest little slip up, isn't it, I think, that really shines through for me. It's just not deleting those cookies on your old computer and sending that wrong email back that often triggers all of these events and the investigatory part of it. So, you know, it's quite fascinating how silly people can be sometimes. So, as we said, I hope you found that really useful. We're going to now launch into a sort of a Q&A session. I've got quite a few questions that have been submitted, but if you have got any questions, please pop them into the Q&A box and we'll do our best to answer them. I think first interesting question here that's come out, and I think this is one for you really, Ellis, is I don't currently have any restrictions in my employment contracts. Can I now get a current employee to sign up to these now?
Yeah, really, really good question. Absolutely. There's nothing stopping you from implementing those. What you do need to do is make sure that you're implementing them correctly. So you've got an employee. I'm going to assume that there's some sort of employment contract in place, but without those restrictions, and that's fine. So what we'll be doing is, as I mentioned before, tailoring those restrictions to make sure we are implementing the right level of restriction for that employee and inserting them into the employment contract. Now, by inserting them, we are changing or varying the terms and conditions of their employment. So we can't just do that without consulting with them and without their consent. So what we would be doing is having a conversation with them, talking about it with them, consulting, but more importantly, ensuring that when we make those changes, a really useful tactical tool is to time that with either a pay rise or a bonus, perhaps a little Christmas gift or some sort of consideration. I mean, Christmas bonus is brilliant because we're coming up to Christmas now. So if you're sat there thinking, you know, I don't have any restrictions, I need to implement them, now would be the perfect time to be, you know, spending the next couple of weeks, as I say, bird's eye view, thinking about who they are, what type of restrictions they need, consult with the employee and offer to insert those restrictions in exchange for something like, you know, a Christmas bonus, a pay rise. So yeah, absolutely possible. It's not going to be a massive headache. It just needs to be done correctly.
Good to know. Thanks, Alice. And I think another question that just has come off the back of that, I think people are feeling guilty about making people redundant, seeking to enforce restrictive covenants off the back of that. So the question is, can you enforce restrictions after making somebody redundant? Yeah,
absolutely. So the basic position is, in theory, yes, you can. Obviously, if you've got an employee with 2 years plus service, then they'll be entitled to a statutory redundancy payment, but also the usual contractual entitlement, so notice pay, you know, pay in lieu of holiday, etc. So provided you haven't breached that contract, provided you've not, you know, underpaid them notice, not paid their holiday, as long as they're leaving with everything to which they are entitled, you as the employer, you've not breached their contract, the contract still stands, and therefore those restrictions will continue to apply. Absolutely.
Brilliant, thanks.
That's actually a really interesting point, Ellis, about you saying that as long as you haven't breached, because obviously the impact, if there is a potential breach, is that it would mean that the contract would fall away and potentially you wouldn't be allowed to rely on those restrictions. So yeah, just supporting what you're saying in terms of just making sure that all those dots are joined up so that you don't find yourself in a position where you can't rely on them.
Absolutely, yeah.
Inadvertently breached.
Absolutely. Brilliant, thanks for that. Another question that was submitted is, David here, the use of iPhones, I think for tracking purposes, are iPhones a really effective tool that you use in that sphere?
I'm actually not the technological one within our business, so I don't actually do anything with regards to computer forensics. But obviously, yeah, there are tracking facilities on the iPhones. Again, it depends whether it's going to be an employee one and whether it is going to be a personal one. But I would also refer back to the solicitors, you know, with the solicitors to make sure that you can be monitoring and tracking that iPhone. The one difficulty with regards to iPhone devices is once they are set back to factory settings, you can't retrieve anything from there. And the case that highlighted absolutely all of this was the Boston bombings, when it was actually Mossad that opened up the devices for the Americans, and Apple said that they weren't going to because of breach of human rights. But there is an inference there that if somebody has set a device back to factory settings, why have they done that?
Mm-hmm. Good to know, thank you. And just some questions that are coming in now. David, I think this one's for you. I'd like to understand more about how hidden cameras, covert recordings, etc., does not expose a company to human rights infringements.
So the basic principle of it is that the Human Rights Act and Regulatory Investigatory Powers at Work Act refers to public authorities. Now, if you're a public authority, you have a designated RIPA officer and they dictate what can and can't be done. And I can tell you that you will never get sanctions for a covert tracking device within the public sector. If you take the spirit of RIPA and Human Rights Act to every investigation, you won't go far wrong. So is what you are doing deemed reasonable for what you're trying to achieve? So if you have, for example, a managing director that's diverting business out of the organisation and they're doing it from their office and it has a detrimental effect, I would say that putting a covert device where you're going to gather that evidence is absolutely reasonable and appropriate for what you're trying to achieve.
Okay, and another question there, I think back to you, Ellis. If the protected employee is still in employment when they're doing naughty bits, I think, what is the view on evidence derived from covert investigations by an employment tribunal? I guess what we're looking to look at there, I suppose, Helen, is what you're trying to get at, is would that then amount to sort of a constructive unfair dismissal type case, that type of thing? So, Ellis.
Yeah, absolutely. I suppose, I mean, ultimately, if an employee is acting in a unusual and sort of challenging way that makes you start to think, okay, there's something going on here, then you know, it's open to an employer to carry out a reasonable investigation if they suspect an act of misconduct. And of course, you know, the types of things we're talking about, so unfairly and, you know, using confidential information in an unauthorized way, for example, priming those key clients that you might be moving, that of course is not going to be in line with your, you know, the duties that you owe your employer. It's going to be an act of misconduct, if not gross misconduct, and therefore it's perfectly acceptable as an employer to be carrying out a reasonable investigation. I suppose the kind of covert investigation element of that question, I mean, there's legally covertly investigating and illegally, so a key difference there, of course, picking up on David's point, we need to make sure what we do is legal. I mean, there's been cases where employment tribunals, for example, sort of separate matters, but employees have spent, you know, the best part of 9-10 months covertly recording every single meeting they've attended, and clearly that was dishonest conduct, and you know, those minutes from those meetings weren't taken into account. But yeah, in theory, if you have an employee who's still employed acting in this way, it's going to be possibly misconduct, if not gross misconduct. You're fully entitled to carry out a reasonable investigation to satisfy, you know, what's going on either way.
Brilliant, thanks for that, Ellis. And another question, I think, directed more at you again, Ellis. Would a restriction on setting up a competing business within a defined area for 12 months be seen as excessive? I think that brings us to the proportionate you know, restriction in the contract, that thought process in why is 12 months, I guess. So what are your thoughts on that?
Yeah, so I guess, you know, it's a bit of an easy kind of cop-out answer, but without knowing exactly who we're talking about, you know, to whom does this restriction apply, it's very difficult to say whether it would be excessive. I'd be minded to say that most restrictive covenants, whether they are stopping someone from setting up, you know, a competing business or a non-compete clause, or non-dealing or non-solicitation of clients, 12 months is a very long period of time. So unless we're dealing with someone who is extremely senior, so we're talking kind of, you know, MD level, FD level, you know, really, you know, good rapport with clients and contacts, really experienced, really senior, is going to pose a very high commercial threat to you, I would probably stay away from 12 months. That does, to my mind, seem excessive. There are bound to be circumstances that it would be proportionate. But again, I think 12 months, you know, you'd be talking someone very, very senior for that to be successfully enforceable. Yeah,
and we've just added in there that it's a very specific director role in a very specific source of income, not sort of MD level. The word director there, I don't think meaning statutory director. I'm just So
again, I suppose without knowing exactly how much contact they have had. I mean, I suppose if they're a funeral director, if they've played, you know, they've been with you for, you know, a good number of years, really experienced, know, you know, your clients and customers quite well. I suppose particularly given the type of business that you're in, you're dealing with people on a very personal level. They're in a very vulnerable position. So I assume that rapport, that relationship that's built is quite strong. So I would probably stick away from sort of 12 months. I'd be thinking perhaps more along the lines of perhaps 6 months. But again, without actually having more information, it's difficult for me to completely confirm that. But yeah, 12 months is probably excessive, I would say, yes.
Just to pick up on that, I know from our experience when we've actually gone through sort of the court proceedings element and applied for interim injunctions, so particularly at an interim stage, non-compete clauses are always more difficult to enforce. Generally, if you've got restrictions in place in terms of non-solicitation, non-dealing, so you've got those other protections in place, the court will therefore be questioning on what basis you can stop that person from actually earning a living, and the court will actually, if you've got those other adequate protections in place which stop them from targeting your clients and your customer base, then you need to really be justifying why that additional restriction is needed. So it is a more difficult hurdle to climb.
Thank you. Right, I've got a few more minutes. Jenny, I've just got one for you that was submitted as well. And I think this is probably the $1 million question for you. How quickly can you get to court on these matters? I think employers get frustrated, I think, with the time it can take sometimes. So how quickly could we actually get there?
In terms of, and again, is it, like you say, $1 million question? If you've got the evidence together, then the whole purpose of an injunction is that it is a quick process. So ultimately, once you've got all that evidence together, you've prepared that witness statement, you get that into court urgently, you can have a hearing within that same week. Obviously, it is a costly process. And I think that's the other question that clients generally will ask us. Firstly, how long is it going to take and how much is it going to cost? Because it's urgent, because there's a need to front load effectively by providing all that evidence and getting it before the court in as succinct and clear a way as possible to support your end goal. It is more costly, but the benefit of it is, and this is what we typically see, once you've got that order in place and you've stopped someone in their tracks, like I say, they're at such a cost risk going forwards, that more often than not, they will come to the table and you can agree terms of settlement. So while it's, like I say, an upfront cost, fairly significant, it should actually result in a conclusion quicker than if you were to drag it forward for a whole length of a court case, which could potentially be up to 18 months. So in terms of getting the interim injunction, you can get it quickly. And like I said, particularly if you don't want to be giving the other side notice of that hearing, because you normally need to give 3 days notice. If you don't want to be giving to them notice, you want to get it before court, it's really, really urgent, the court will hear and listen to it urgently. So it can be dealt with urgently, it comes at a cost, but the benefit and the upside of that is that hopefully you can resolve it fairly swiftly once you've got that order in place.
Brilliant, thank you. Right, I've got a few more questions, but I'm conscious of time, so I think what we'll do is we'll wrap it up there now. So I want to say a big thank you to Ellis, Jenny and David for your time today. That was a really interesting, insightful talk, and I hope everybody's enjoyed it today. Thank you for coming along, and we do hope to hopefully see you all in person sometime soon. So take care, everyone. Bye-bye.